Welcome to this seminar on reopening of criminal cases in Spanish law. We are currently in Barcelona, and my guest speaker here, Núria, will introduce herself after this brief introduction by me. My name is Frederik Waage, and I'm a professor of law at University of Southern Denmark. This seminar is an attempt to follow up on the Danish case concerning Ahmed Samsam, the Danish Supreme Court case, which came in September on the 2nd, 2025. And I would like as a start for this seminar to briefly present some of the relevant parts of the Danish Supreme Court case, which has an importance here. But first of all, I should say that this seminar is a cooperation between the University of Barcelona and University of Southern Denmark. And I'm here with the Spanish Associate Professor Núria Miret, who is a professor who deals with Spanish criminal procedural law. If I may briefly start, and I hope that the participants who are online here will be able to follow the slides and everything works. Otherwise, we should be able to get comments on the chat if something doesn't work. But my introduction here is just a few minutes of description of the Danish Supreme Court case, which is the reason why we are here. In June 2018, Ahmed Samsam was sentenced here in Spain to 8 years imprisonment for participation in a terrorist organization. The conviction was based on 3 trips to Syria in 2012, 2013, and 2014, where he allegedly fought for groups that later became part of Islamic State. Samsam's appeal was rejected by the Spanish Supreme Court. In November 2020, Spanish authorities decided the sentence should be enforced in Denmark as 6 years of imprisonment. Samsam was transferred to Denmark in December 2020 to serve the remaining sentence. During his imprisonment, Samsam claimed that his 2013 and 2014 trips had taken place in cooperation with Danish intelligence services. Samsam asserted that he had worked with PET and FE, that is the Danish Secret Services, the Danish Security and Defense Intelligence Services. He stated that the cooperation was authorized and financially supported by them, and he therefore brought a civil action seeking formal judicial confirmation of his cooperation. The key questions in the Danish Supreme Court case, which was decided in September 2025, was: did Samsam have a sufficient legal interest in bringing the case before the courts? And had Samsam proved that he actually cooperated with the intelligence services? The case raised fundamental issues of secrecy, accountability, and citizens' access to justice in intelligence matters. The Supreme Court stated that, as a general rule, persons cannot require courts to determine whether they have acted as sources or collaborators for intelligence services. This is due to the special functions and confidentiality of PET and FE. The rule applies even where the services are not compelled to confirm or deny specific facts. An exception may occur only in very exceptional cases where the citizens' rights to clarification outweighs the need to secrecy. Samsam additionally argued that he had a sufficient legal interest in having the case heard before the Danish court. Unless he reached a satisfactory resolution with the Danish authorities, he intends to apply for reopening of his Spanish criminal conviction. And according to the Spanish Ministry of Justice, Spanish law allows reopening of a criminal case when new factual circumstances emerge after the judgment. This is exactly what we're going to discuss today. Such circumstances must be of a kind that could have led to acquittal or a milder sentence if they had been presented during the original trial. And what the Danish Supreme Court also focused on was the fact that evidence from the Danish intelligence services could have influenced the assessment of facts and conclusions in the Spanish judgments. This was, according to Samsam, also reflected in the ruling of the Spanish Supreme Court. After reviewing all testimonies and evidence, the Danish Supreme Court held that Samsam had proved he cooperated with Danish intelligence during his 2013 and 2014 trips, and consequently the Supreme Court overturned the High Court's dismissal of the lawsuit. This was just a brief introduction to what the outcome was of the Danish Supreme Court case and the reasons why it was necessary for the Supreme Court to review and focus on certain matters. What the Danish Supreme Court found was basically that it could not be ruled out that if it meant something, that it was proven in the Danish courts that Mr. Samsam had worked with the Danish intelligence services. He had a legal right to have that established by the court. And now we have a Danish Supreme Court sentence which concludes that Mr. Samsam, in fact, was collaborating with the Danish intelligence services while he was in Syria for 2 years. Now the reason is, based on all this, what can Mr. Samsam do, and what are the options now if within the Spanish criminal system? And that is the purpose of the seminar today. What we will focus on now, and I will give the word to Professor Miret from the University of Barcelona. What we will focus on is the obligations of the prosecutor to investigate the case. Mr. Miret will give a full presentation of how the system works. Now I'll ask questions about where we are at present and what we can do with this Danish Supreme Court case in Spain. But I'd like to give the word to Núria Miret from...
Thank you so much, Professor Waage. Good morning to everyone. First of all, I would like to thank the organizers, the Southern University of Denmark, and especially to Professor Waage for inviting me and giving me the opportunity to speak today about the proceedings to review final criminal judgments in Spain. As he has mentioned, I think that this seminar, it's quite timely. And as I have discovered in the latest weeks, it has been a very controversial and important judgment in Denmark. So I'm so pleased to be here and to help as far as I can explaining how the Spanish system works. As he has introduced me, I'm sorry because I'm going to share my own presentation. Just wait for a second. Here it is. Sorry. Okay, so everything is set. Well, as he has already introduced, I'm a professor of criminal procedure at the University of Barcelona. And my interest in these special proceedings to review final judgments comes from the Barcelona Innocence Project, with its legal clinic that we have established at the law school in the University of Barcelona, where we analyze and we work in cases of people who contact us saying that they are innocent, but they have been convicted for a crime. So I think that, as I said, that's quite timely because we work in this kind of cases that Mr. Samsam claims he is in. So I'm going to explain how it works in our system. The question or main question we have to answer, or the first question we have to answer, if it's can a criminal case be reopened according to the Spanish law once the judgment is final? The answer is yes. And now I'm going to explain which kind of proceedings are available for all those citizens that claim to be innocent, or who claim that there has been a mistake in their judgment. This proceeding is called Appeal for Judicial Review. This is the official translation from Spanish, which is called Recurso de Revisión, although it's a special proceeding which seeks to undermine res judicata effect that is produced by final judgments. So this proceeding is ruled in our criminal procedure law, the Spanish criminal procedure law, in sections 954 to 961. And I would like to mention, because I think that it's important something to fully understand how this proceeding works and our regulation, that the Spanish criminal procedure law dates back to the 19th century. So it's been with us for more than a century right now. Of course, it has been modified several times. Also, the appeal for judicial review have been modified. I think that first times it was modified, it was in the 30s from the last century. Afterwards, in the 90s. But the most recent change was made in 2015, and it was an important and relevant reform, the one that was done back in 2015. And I'm going to explain the differences between the previous system and the current one, because I think that it's important to correctly understand and know where we are right now. As I said, it's an exceptional remedy, so it can be initiated only under some circumstances, and these circumstances are set on section 954. On your screens, you can read all the circumstances. There is a total of 7 circumstances under which the case can be reviewed by the Supreme Court. The jurisdiction is from the Spanish Supreme Court, the second chamber, which is the criminal chamber, and it's located in Miret. There's only one court. As you can see, there are 7 circumstances, number 1, 2, and 3. The first circumstances are the old ones. And letter E and paragraphs 2 and 3 are the newest ones. Those were introduced in 2015 through this important reform I previously mentioned. I'm not going to deeply explain all them, because I assume that the interest in the review proceedings has to do with the Samsam case. So I'm going to mention some of them with some examples, but I'm going to focus on circumstances of letter D and E, which are new facts and evidence, the appearance of new facts and evidence, letter D, and letter E to get a judgment of a non-criminal court that may affect interpretation that a criminal court previously made of the same facts or issue. I think it's important just to explain the difference between both circumstances, although I think that it's important to bear in mind that E didn't exist till 2015. These circumstances are limited, but prior to 2015, all cases that could be lead to these circumstances were decided or were covered by letter D. That's why scholars have said that letter D is the general circumstance, the general cause that could cover all the other circumstances. I think that this is important to bear in mind. As I said, I'm going to pay attention to letters C and D. D and E. Regarding letter D, on your screens you can read the original version of this paragraph and the current version of the paragraph of these circumstances. It was modified in 2015 because the Supreme Court and also the Constitutional Court have interpreted this circumstance in a wide manner. So the legislative in 2015 not only included or added extra circumstances or new circumstances to the provision, but also modified the ones that were already set in the section to adapt them to the Supreme Court and the Constitutional Court case law. As you can see, only the second part of the section have been modified. And it's quite an important reform because it widens quite a lot the frame of this section. As you can see, the original version required to have new facts and new evidence that have come to light to prove innocence. Right now, the section provides that you need to have new facts or a new piece of evidence, which if they have been provided in trial, they could have determined an applicable or a less severe sentence, which can make a difference because it widens the scope of the section, allowing more cases to fit in the section. I'm gonna explain how this second part of the section has been interpreted by the Supreme Court, but I think that it's important to also pay attention to the first part of the section. So the first requirement is to get new facts or new evidence. What new facts are? That's the questions. The Supreme Court has stated that new facts are those that happened after the judgment or those facts that had already occurred before the judgment but were unknown by the defendant or by the court. So if they are unknown and they are known later, they can be brought to the Supreme Court to review the case. It's important to bear in mind these new requirement, because that means that this proceeding is not an ordinary appeal. We can review all evidence that was brought to court in trial. It has to be new. Okay. And with facts, it's also allowed to bring new evidence, new pieces of evidence. When the law requires to get new evidence, it refers to those evidence that can be produced later, that were unknown for the defendant or for the court. But also, it refers to those pieces of evidence that couldn't be brought for reasonable reasons. I think it's important to say that these reasonable reasons could be because these pieces of evidence were out of the reach of the defendant, for example, that it was impossible for him or for her to get them, or, as I said, that they were produced afterwards. The second requirement, which is the second part of the section, right now states that if they had been provided, it would have determined acquittal or a less severe sentence. What does it mean? It's important because, as I said, right now, those new facts or those new pieces of evidence that can be brought to court doesn't have to prove innocence. It's enough to bring a piece of evidence that can modify the assessment that the court originally did when they issued their judgment. This you don't need to prove innocence. It's enough to raise doubts in the court. So, in dubio pro reo can operate once again. And if there are doubts, you know that the court must acquit. So, if these doubts rise in the Supreme Court will overturn the judgment, the original judgment, and the case will be reopened. What is going to do the Supreme Court? The Supreme Court is going to compare the facts at issues, and it's going to put all evidence together, and it's going to check if that new evidence is relevant to modify the judgment, to make those raised, as I previously said. So, in order to be successful, you need to fulfill both requirements. The second circumstance I said that I would mention is the one set in letter E. It has to do with contradictions that can appear between two judgments, one from a criminal court, and one from a civil or an administrative court. Sometimes when the criminal judge has to apply criminal law, need to refer to concepts that are not of criminal nature. And they have to assess evidence and facts that lead them to apply or to interpret a civil or an administrative regulation. These issues are part of the crime description itself, but are not real criminal provisions, because are matters of they have a different nature. So they can be decided also by another court, and the civil and the administrative court, usually these ones, may issue a judgment, and there can be a contradiction between both judgments. This contradiction, it's relevant, of course, and it's important because our system shouldn't allow these kind of contradictions to exist, because as the Supreme Court have stated, there can be a fact that for a court exists and for another one doesn't exist. So it has to be clear the real situation. So that's why there is this circumstance. This circumstance previous to the 2015 reform, as I previously mentioned, was included in in number 4, that it's the current letter D. In any case, these contradictions or these circumstances have to do with legal concepts, okay, not facts. Of course, to describe legal concepts or to get to legal conclusions, we need to take to assess facts that they have to do with legal concepts, and the contradiction have to be relevant. What does it mean? To be relevant, it has to affect legal certainty. It also, when a judgment declares that a fact exists and another judgment declares that it doesn't exist, it's relevant because it's a fundamental contradiction. And also, it's relevant when it attributes organized authorship to a person, which means that for a judgment, for the criminal judgment, for example, a person was was liable for the fact and for the crime, and for example, for the administrative or the civil court, that person was not liable. Well, of course, as I said, we need to seek at any case if those circumstances fit in one of these cases, the 2 I have mentioned, or one of the 7 cases that law provides. If it fits, the proceeding may be initiated. I'm going to explain or briefly explain how the proceedings work, the procedure. But first, I would like to stop for some minutes in data, just to put you in context of how this special proceeding works, and how much success it have, how difficult it is to be successful. So just to put you in context. Well, here in the screen you can see I did a quick table, including the figures of the number of judgment and files that had been reviewed by the Supreme Court from 2020 to 2025. As you can see on your right, 2020 is an exception because there were many petitions. Many petitions were lodged, 459, but there is an average of 2,050 petitions per year. These figures were found in the official statistical data from the Supreme Court, and they refer to the number of petitions that were lodged before the Supreme Court. In the middle, you can find all the published rulings I have found in public database. Figures are different. This, I think that it has to do with the criteria to publish them on the database. And on the left, you have the number, the figures. These figures are the number of judgments that had been issued each year by the Supreme Court. Why there is a difference? Why I'm saying that there is an average of 20, 30 cases per year? 20 to 30 judgments per year, but there is an average of 2,050 petitions per year. That's because we have a two steps proceeding. So we only get judgment from the Supreme Court if the case gets to the second stage. So as you can see, most of the cases stay in the first stage. So it's very important to get the authorization to get to the second stage, as I will mention later. I also included some data. I'm sorry because I took the original tables from this work made by Maria Novoa, who was a former student of the legal clinics. She did her master's degree dissertation about this the review proceedings. And I took the data, these tables from her dissertation. And she took data from 2016 to 2023. 2016, because it was when the new version of section 954 was first applied. And she outlined that most of the cases that were heard by the Supreme Court and decided had to do with letter D. That the most frequent claimed circumstance is to the one referred in letter D, to have or to get new facts or new evidence. 63. And the second one is it's circumstance under letter C, which is non-bis in idem cases. There are a lot of cases. These are not wrongful conviction cases because it's just miscarriage of justice. Justice work didn't work properly. So two courts decided the same case twice. So as far as there can be two judgments at the same time, the second one has to be overturned. And these are the non-bis in idem cases. These cases are easy because the court only have to check if the facts are the same and that the person has been convicted twice for the same facts. These are easy cases. And also are most of the other cases that can be included in those 63. Let me explain this in further detail. What I mean when I say that these are easy cases, I mean that these are quite easy cases to, because the evidence of the fact that supports the claim on petition, it's objective and it can be quite easy to take. For example, most of the cases, I think, yes, you have the data here. I included the table. Most of the cases that are heard by the Supreme Court has to do with traffic offenses. There are two different crimes. The first one is driving without license, and the other one is are cases that has to do with driving having taken alcohol. And the first type are always cases in which the convicted person claimed that they have, when they were convicted, they do had a driving license that was obtained in their country of origin. These cases had always involved someone who is a foreign from many different countries, and once they had tried and convicted, they claim that they have in their country of origin they obtain a license. So the case is overturned as far as they can show and bring to court the original driving license. And the cases that have to do with driving under the effects of alcohol, most of them have to do with misidentification. False testimony, people who, when they are identified by the people, say that they are another person. So the real person who is convicted prove that it wasn't them, the ones who were driving the car, and if they can prove that, the judgment is also overturned. There are many others, but there aren't too many high-profile cases. There aren't too many murder cases, terrorist cases, sexual assault cases. I can see 2 sexual cases that if you read and translate the different types of crimes, you are not going to find terrorism, or you are not going to find in the list murder. There are some, but these are very, very difficult cases because evidence is very difficult to obtain. Well, I'm not going to move towards the procedure. First, who has legal standing to initiate the case? There are 3 different sections that provide legal standing to different people and actors. Section 955, 954, paragraph 3, and section 961. As I said, it's our criminal procedure law is old, and when it's modified, sometimes different provisions are added just in different places, and that's the reason why we have 3 different sections that rule standing. Who has a standing? The main provision is section 955, the one you have on your left, that provides legal standing to the convicted person, and if he or she has deceased, to her or his relatives. But also the general attorney, the general attorney has standing to bring the case before the Supreme Court, but only in those cases where he gets notice of the situation, the circumstances, and they get to the conclusion that these circumstances are sufficient, based, of course, in the information that they have gathered. There is a very similar provision. Also, the Ministry of Justice, through an administrative file, may order to the special prosecutor of the Supreme Court to bring the case before the Supreme Court. And of course, this is a very similar provision to 961, because they need to have notice of the circumstances, and they need to think that there are sufficient grounds to initiate the action. Which is the procedure? As I previously mentioned, this is a 2-step procedure. The first step, or the first stage, it's what I have translated as the request of authorization to lodge the appeal. And the second step is the review proceeding itself. So first, there has to be a petition that has to come from one of the persons that have legal standing, the convicted person, the relatives, the public prosecutor's office. And after a short investigative proceeding, the court is going to decide if they provide authorization to lodge the appeal or not. In this proceeding, only in the case that the proceeding has been initiated by the convicted person, not when it has been initiated by the public prosecutor's office, the public prosecutor has to file a report where they have to express their opinion, in the sense that they have to agree or disagree with the petition and explain the reasons why they reached to their conclusions. Both the petitioner and the public prosecutor may ask for investigative proceedings to be conducted. So they can ask the court to carry out evidentiary activities to get those pieces of evidence that they couldn't bring for themselves. The Section 957 provides that they can also ask for judicial cooperation. That I think that it could be also international judicial cooperation. It's important to point out that this first part of the proceeding may take quite a long time if these investigative proceedings have to be conducted. Otherwise, it can take probably between 3 and 6 months. But if the investigative proceedings have to be conducted, it can take much longer. Once the public prosecutor have issued his report and the investigative proceedings have been conducted where needed, because and ordered by the court may grant them if it gets to the conclusion that they can be relevant for the case. But also in the case that they get to the conclusion that the case is clear, they can reject that. And once all this procedural activity is done, the court will provide its authorization to lodge the appeal. So in the second stage, the plaintiff or the public prosecutor can present their breach of submission. And also in this second stage, the public prosecutor may have to submit a report. I want to point out or to note that there can be a difference between the first report and the second if investigative proceedings have been conducted, because there may be extra information or extra pieces of evidence that could be important to get a conclusion. After that, the Section 959 provides that there can be a hearing if the Supreme Court thinks or gets to the conclusion that it can be useful for the case. I personally have never seen one of these hearings mentioned in a judgment, but the law provides that it's possible to order this hearing. And at the end of the proceeding, the Supreme Court is going to issue a judgment, and this judgment can accept the review or can deny it. And if it's accept the review, it's going to overturn the original judgment, and the case will be reopened. And I'm going to finish my presentation here. But of course, if you want to ask and you want to go deeper, to dive deeper in any of the questions I have mentioned, or you have doubts of something that I haven't mentioned, please be free to ask. Thank you so much.
Thank you so much, Professor Miret. And I'm very pleased that we now have had the opportunity once and for all to get, in my view, to the bottom of how this procedure actually is. I mean, getting understanding the legal framework, and that is something I think that we will sometimes even rewind the video and be sure that we understand the aspects of this. It is very helpful. And this leads us now to our next guest speaker, Professor Lasse Lund Madsen, who will join us from Aarhus University. Hopefully it should work. I have invited him now and allowed him to speak on Zoom, and he should be able to join us with a short presentation. Afterwards, we will follow up on all kinds of questions for Professor Miret. But I hope you can hear us, Lasse.
Well, I just have to give a short presentation here, and thank you for Núria for this interesting insight in your system. Just a short comparison with the Danish system, of course. Reopening of a case is also an extraordinary legal remedy in Denmark. And on one hand, judgments must be final and binding, and on the other hand, especially in criminal case, it is about finding the truth and avoiding miscarriages of justice. As I understand you, it's your Supreme Court who makes the decision in Spain. In Denmark, we have a special appeal court, which is a court-like body that consists of 5 persons, 3 judges, a professor from the university. I'm actually first alternate for one of my colleagues who is a permanent member of the special appeal court. So I have dealt with these cases every now and then. And then there's also the 5th member of the special court in Denmark is a lawyer. So that is just a brief insight in the Danish system. But of course, at the end of the day, the main thing is whether there is new evidence which are substantial. They have to be groundbreaking or decisive to the case. It's not enough that a witness wants to change his or her explanation. We have to have new substantial matters on the table, so to speak. If I now turn to the Samsam case, it's also worth noting that in Denmark, when you appeal a case, you start from scratch in the appeal court. That means that you hear all the evidence again in an oral matter. All the witness explanations are repeated for the appeal body. As I understand, in Spain, that is not the case. The appeal was conducted in writing. So we have some differences there between Denmark and Spain. But if I now turn to the case itself, of course, in Samsam, it was a central argument in Samsam's defense that he had been an agent for the Danish state, for our intelligence services, first for the police intelligence service, that is PET, and secondly from the defense intelligence service, that is FE. And he sought confirmation with the Danish authorities that he, in fact, had been an agent, but he was met with a wall of silence, you could say. In my opinion, a confirmation would have been material to his case, because under Danish law, at least, and I understand, it's my understanding that it's the same under Spanish law, that the actions you undertake as an agent in agreement with the authorities will be exempt from punishment. But this was his status of being an agent was never confirmed by the Danish authorities. Actually, it's somewhat surprising that the Spanish Supreme Court, in their ruling, actually states that the Danish authorities had denied any cooperation. The Danish authorities, however, as I understand it, maintained that they have neither confirmed nor denied anything, and that has been their argument throughout the civil case here in Denmark. But of course, if I look on this case through the eyes of the Spanish judges, this statement from Samsam must have been very untrustworthy. It have been far-fetched, I would imagine. So it was pretty clear that they didn't believe him in any ways. And the Spanish Supreme Court stated that, and I suspect that would be for what can I say, just to because he had this argument and they couldn't get this confirmation, or it was denied, whatever was the case. And they have 4 or 5 lines that have become pretty important in Denmark, because the Spanish Supreme Court said that an occasional cooperation would not have made a difference. They used the Spanish frame puntual colaboración, and it's my understanding that this means an occasional cooperation. However, it was mistranslated into Danish. Thus, it was translated into a precise or a permanent cooperation. And actually, the Spanish Supreme Court tried to say the opposite. So this had a huge impact on the Danish court case, this error in translation. That's why I called my... I talk about that Samsam was lost in translation. When the case pended for the Danish Supreme Court, there was a new translation, and it was translated into that an occasional cooperation wouldn't have made a difference. But the Danish Supreme Court found that his cooperation with the Danish authorities have indeed been on a permanent basis, that he actually got a monthly salary for his cooperation with the Danish authorities. They transferred money to him when he was in Syria, and that is one of you could say the grotesque things about this case, because these 4 money transfers, the Spanish judges mistakenly believe are part of a terrorist financing, but they actually come from the Danish state, from his contacts within the intelligence services. So in my view, I think that this information, but I'd like to hear what you think, Núria, that in my view, had this information been public or been accessible for the Spanish judges, it would have been, in fact, material to the case, because the actions you undertake as an agent will be exempt from punishment as long as you fulfill your duties that you have agreed with the Danish state. And it's my understanding that he actually did that exactly. So that was, that was it from my part.
Thank you very much. We turned out the dog working for a second. But thank you very much, Lasse Madsen, the professor from the University of Aarhus. And I think we will follow up on the comments from Lasse right away. However, if I could just as an initial question here, and that would also mean that we will open up for the debate. We have. Of course, I've given access to all the participants of the debate here to take the word, to raise. They can raise their hand and ask if they have any questions. I would very much like to, of course, share your comments on Mr. Lund Madsen's questions before. But if just as a starting point, just to be sure, we focus here on the procedural matters, and then we'll also get into this later on. As I understand your presentation here, we have a system which is being used very often. You have many cases in Spain about reopening. The procedure is there. It is also, in comparison to the Danish system, probably a process which it is certainly a procedure which is used frequently and also more often than in Denmark. You mentioned that there were actually 2 possibilities of starting up the case, the reopening case. First of all, the case could start up by means of the prosecutor themselves, that they could do it, and then of course Mr. Samsam himself and his attorneys could go for a complaint. I find it very interesting to know that actually the prosecutor could have a special role here, especially also in light of administrative law principles. And my question to you, the first question would be, now we have a Danish Supreme Court case which states that Mr. Samsam has been that has been an agent for the Secret Services. If the Danish Ministry of Foreign Affairs or the Danish state in any way, the Danish Ministry of Justice contacted took a contact to the prosecutors and gave them the Supreme Court case. First of all, would the prosecutor be obliged to look at the case and consider to take it to court? And would it be an advantage if the prosecutor, him or herself, took the case to the court instead of Mr. Samsam taking it to the court? So that this was two questions, if that's possible to be true.
Yes. First question is, if the Danish government in general censor the information to public prosecution, I think that they are going to look at it and they are going to assess that information that had been provided to them. And they are going to decide if that information and all the documents are pieces of evidence that can be attached to the information itself are relevant enough to bring the case before the court. If they get to a conclusion that it's relevant, they will. If they don't get to a conclusion that it's not enough, they won't, because they don't have to. They may decide if they have a case or if there's not sufficient evidence or sufficient information to reopen, to go before the Supreme Court. Or maybe they get to the conclusion that it's not relevant enough because that information is not going to be significant and it can change the judgment. So they are going to assess what they get. And if they reach the conclusion that it's relevant, they are going to bring the case before the Supreme Court. But they are not obliged.
And would it be an advantage that they did it instead of Samsam doing it himself?
Once the petition is done, the procedure is as the same. Mr. Samsam will be contacted, and the Supreme Court will offer him action, so he can decide to join the appeal, or he can decide not to appear before the court. So the procedure is going to be quite similar. The main difference is that, as I said in my presentation, that requirement that the public professor Guter have to issue a report with its opinion, that part is not going to be carried out, because as far as they have submitted the petition, they already have informed the court of their opinion. But in the other aspects, the procedure is going to be more or less the same. There's not going to be but I think because we talked about that previously, but the point is that as far as I have read many different Supreme Court judgments, I must point out that 90%, between 90% and 100%, it depends on the year, of the cases that get to the second stage, and so that the Supreme Court issue a judgment. So those 20, 30 cases that get a judgment from the Supreme Court, usually 90%, 100% are successful. So the judgment is overturned. So what does it mean? It means that all cases, all petitions are filtered in the first phase. It's important to get to the second stage. If you get to the second stage, there is a high rate of possibility to be successful, but you need to get to the second stage. And I have no doubt about this because I haven't done any empirical research about this, so it's just my personal impression. From my readings, I also noticed that usually the Supreme Court follows the prosecutor's office opinion. And also some other colleagues and scholars have pointed out this circumstance. But this is just statistical data.
But what will the statistical data say?
Statistics. Yeah. It's not that the Supreme Court has to follow the public prosecution opinion. No.
But just to make this clear, just to make it clear, it would be that if somebody were to advise the parties how to proceed, trying to get the case taken up by the Supreme Court, there would be a lot better chance if it was the prosecutor who did it compared to Samsam himself, according to the statistics.
According to the statistics.
So it would be a good idea to try to convince the prosecutor to look at the matter, because it's a special matter. It involves foreign civil services and the relationship between states. And ask them if they have a look at it, would they do it? I mean, it is normal for people. I mean, it is normal for the prosecutor actually to do this on behalf of people. I heard there were complaints earlier where the much
notice a full conviction.
Yes,
they bring the case.
They take it as their duty.
Yes, they have to duty, and they take the case. There are. In case law, you can find many cases where the proceeding was initiated by the public prosecution.
So this is new. As I've seen from a Danish point of view, it's new that we now are aware that a way to proceed would be to contact the prosecutor in Spain and tell them about this. And would it make a difference if it was the Danish state that came with the judgment and gave it to them, representatives of the state, or if it was Samsam's lawyer himself? If they were assisted by, for instance, the Danish Minister of Justice, bringing them the case, the prosecutors, would that matter, in any way?
From a formal point of view, there's no difference. From a legal point of view, there's no difference.
And still, if the prosecutor, I suppose, due to ordinary principles of administrative law, also in Spain, if the Spanish prosecutor receives the documents, they should read it.
Yes.
And they would read it, and of course, and knowing the significance of a Danish Supreme Court ruling like this, it is a historic case in Denmark. Mm-hmm. You would believe that, according to administrative law principles in Spain, the prosecutor would read through the documents and make the decision after that. If they receive this from the Danish embassy or from
they are going to read them, they are going to consider them, and they are going to decide if they bring the action or not, depending on the conclusion they get. Because, as I previously said, not all facts or not all evidence is enough. It has to be relevant, it has to be significant, and it has to be enough to modify the court's opinion. You need to raise a doubt, so it has to make a difference. So what they are going to do, all the interveners, they are going to check the facts at issue in the Spanish proceeding, and they are going to compare them with the new facts or the new pieces of evidence, and they are going to consider all them together, if there is a match, and if they get to the conclusion that it's relevant, they are going to bring the case, and probably the Supreme Court will reach the same conclusion. But you need to fulfill all these requirements.
Yeah. And just briefly to understand here again, you have many examples of the prosecutors taking up a case like this. It happens? Yes, okay.
Well, like this, no. This is a quite unusual case.
It's a very unusual case.
This case is completely unique.
And just to get to the bottom of this.
Something like that.
If the prosecutors say that we cannot support to take this to the Supreme Court, then Mr. Samsam can decide himself to go follow. So this is the second chance. So we can start here, try to persuade the prosecutor. In my view, I would say go to the prosecutor, take the Supreme Court with you, and if you could have support from the Danish government, it would be a strong case. You say that informally that should not matter, but at least Samsam could also himself go to the prosecutor. If they say no, he can go himself before the court.
Yes.
And then getting back to
even then, the public prosecutor can join the patient, because there is this this stage where they have to inform, they have to issue a report. They can say, yeah, we agree with Mr. Samsam, or we don't agree with Mr. Samsam. Of course, they can provide their opinion in both senses.
Okay, and getting back to the question from Madsen now, you have also read very briefly the text, and we're not going into any sort of evaluation by you of how you see the case in substantially. But Mr. Madsen asked in this case about the fact that there was a wrong translation in the case, and you're aware of this. Also, this idea about vocational engagement, but also if we look at the matter of the case, the Danish Supreme Court has noted that in fact, if it was a longer relationship he had for several years in Spain, in Syria, that it could not be ruled out that it could be an argument for reopening the case in Spain. What do you see? What do you think about such arguments when you see them presented here?
Can you
repeat
the question?
Yeah. And Mr. Madsen informed us before here that there was a problem with the translation.
Yeah. Yeah, I'm aware of this because I've read the Danish judgment.
Yes. Just as a start, what do you think about that? Could that be an option? Could that be a reason for reopening the case?
As I said, I think that if you ask me, that's a foreign judgment which states that Mr. Samsam, we should read the literal of the judgment, that it says something like, it's proven that Mr. Samsam traveled to Syria in accordance with the Danish government. I should read the literal of the decision.
Yes.
But this is what matters in my point of view. So the Supreme Court is going to consider if it's what they previously considered, because it has to be new. Okay. But what's important is that you have a judgment from a Danish court that says that it's proof that they collaborated.
Okay.
So I think that this is, in terms of, is this a new evidence? Yes, I think it's a new evidence. This judgment, it's a new piece of evidence that can be considered. What is going to do the Supreme Court? They are going to check if it's the same or not that they already assess.
Mm-hmm. Yes.
Apparently, it's different, but they are going to check it.
Okay.
And afterwards, we need to fulfill the second requirement. So because there are two requirements, it has to be new and it has to possibly modify the judgment. It has to be strong enough to modify the judgment. It has to be relevant. It has to be significant, and it has to rise into the court doubts.
Great.
So that's what the Supreme Court is gonna do. I can go farther because I've just read the judgments and I haven't read the files, so I don't really know what's behind those judgments, because probably there are other proofs that have been presented to the court that I don't know, because I haven't read the complete files, neither the Spanish ones, neither the Danish ones.
And we'll focus mainly here on the procedural issues. And I want to say now that we have actually, we have the last up to 30 minutes left. I want to open the questions to everybody. If somebody has comments or questions, Mr. Madsen is obviously also very welcome. Do you have any follow-up questions, Lasse?
Yeah. Just to be clear, the mistranslation that I talked about is actually, that was just to explain, that was of importance here in Denmark because that dealt with Samsam's legal interest, but it's actually not of importance in Spain because of the Spanish, there's no mistranslations in the Spanish judgment. That's on the original language. So my point wasn't that the mistranslation could be of importance in Spain. What can be of importance in Spain is, of course, the fact that Samsam, and we now have the Danish Supreme Court's word for this, in fact, was a permanent agent. That means under Danish law that if you are a permanent agent for the government, the actions you undertake in that respect, even if they are criminal of nature, you will not be punished for those actions. And it's my understanding that the actions you undertake as an agent for the Spanish government likewise will not be punishable. Of course, who on earth would be an agent if you were to get punished for the actions you undertake for the government? So I think this is of huge importance. Had the Spanish judges known that all his trips to Syria and all his actions in Syria was actually in compliance with the Danish government, this cannot, by definition, it cannot be punishable under Danish law. And isn't, in fact, that the same in Spain?
Yes. I do understand your question. This is a matter of substantive criminal law, so it's not my field of expertise, so I can't provide you a full answer to the question. What I can see from a procedural point of view, that it's an issue that I think that has to be decided by the court once the case is reopened, because what the Supreme Court does is to overturn the original judgment. So the case is reopened, and the convicted person now is accused once again, if they think that they have to accuse him or her, and they have to try him once again, and they are going to assess once again all the evidence together, putting that new evidence with the other ones, and they are going to reach an conclusion, which can be an acquittal or can be a new conviction. It depends on the weight of that evidence. What the Supreme Court does is just to think if that new evidence possibly could modify the judgment, if it has weight enough to change the decision. But it's not a final decision of acquittal. It's just that they overturn the judgment, and it has to be the court, the Audiencia Nacional in this case, or the district case, it depends on the case, that reopens the case, the person has to be tried again, and there's going to be another judgment.
But if we concluded that the case would be the same in Spain, then in fact the fact that you have been an agent, then it could also be a reason for that procedural decision to reopen the case. That in fact, if this information
it can be considered in the second case, of course.
It can be considered in the second case, but it could also be a reasoning if it was established. If let's say, and it's a purely theoretical issue here, but the question here, if we establish that the knowledge of a relationship with the Secret Services would have an importance, it could be considered new information.
Yeah.
In your perspective, of course. So I think that was just.
I think that this is new information.
Yes.
The first requirement.
Yeah.
I think that we could say, yes, it's something that it's new because the judgment was issued once the Supreme Court's judgment was already final.
Yes.
And bent. So it's new.
And then that, of course, it would be up to the second trial, where it would go back to the district level also, and it would in that case go back to the district level, but as a start, with the possibility of going further if that would be the case. Thank you so much. I don't know if we can, if there are anybody who here from, we have plenty of questions from here we can continue with, and we will go a bit over the time schedule because we were a bit delayed, but I don't know if there are any questions from the panel here. I've given everybody with the right to speak, so I don't know if somebody would take the word here. Then they're most welcome, and we can ask Professor Miret here for an opinion on this. But otherwise, okay, it's not immediately any questions here. Please feel free to join us if that is if that should be the case. Okay. I'm just trying to follow up on your very fine presentation. It's just to be sure because this is new from a Danish perspective. I would say this somebody is no.
I see.
13 years old. Okay. This is new from a Danish perspective. Could we just briefly here discuss the process of reopening? You say again the number is between 10 and 20 successful reopenings.
Yeah. Lately, in the more recent years, it's 30, the rate of success. Yes.
And mainly the traffic offences, just to be concrete here, as you mentioned before.
Yes, the issue is that I think that it's 20% of the cases that are traffic offenses. Many others are business cases that had to do with gender violence orders.
Yes.
Or sometimes with alimony.
Yeah.
But there are business cases, usually this type of cases. And the other ones, the most serious crimes, as you can see, I know I haven't translated the figure. I'm sorry because I didn't have the opportunity to do so. Serious crimes are not reflected in those statistics because it's minimum, or there are just few murder cases, sexual assault cases, terrorism. We are talking about terms-related crimes. These are not frequent cases. I haven't analyzed all those rulings that I told you that ends the proceedings in the first stage. I guess that, or my hypothesis, this is something that a researcher want to conduct, is that most serious cases end on the first stage, because it's or never start, because it's very, very difficult to get new evidence or new facts with these cases.
Okay, we have a question here from, I think, Professor Ada Schmidt from Denmark, joining us with in the name of her daughter Ida. But I think that I'll just try to do the audio so that we can hear her. I'm sorry, Ada, we cannot hear you yet.
Yeah.
We can hear you now. Thank you, Ida, if this is Ada.
Can you hear me?
Yes, we can hear you, Ada. Thank you.
I was just wondering if the prosecutor, you put in your application first, the prosecutor, and if he says no, you have the chance to go to the court. But what are the chances if the prosecutor have said no? Is it really you have this second chance to go to the court? But how real is this possibility? Is it at all possible to go to the court if the Attorney General had said no to your application?
I would like to work out that it's not a second chance. It's just that the law provides legal standing to both, so both can go here.
Oh.
Both can bring the action before the Supreme Court, even at the same time.
Yeah.
So they can agree, or one can take the initiative. The public prosecutor office or the convicted person. So it's not a first chance and a second chance. Is that law permits both the public prosecutor and the convicted person to bring the action, so they can decide if they want or not. Regarding the public prosecutor, as he is led by the principle of legality, I assume that if they think that they have a solid case in terms of, yes, we have this new evidence and we think that it can make a difference, they are going to bring the case before the Supreme Court. But they can get to a different conclusion. So it's the work and their opinion. They can even change their mind later, because the convicted person can bring its own action, and then the public prosecutor office may join their opinion.
We understand. I think, can we hear? We can hear. I hope everybody can hear us still. We just have some technical, so just to be sure that we are not muted now. No.
Yeah, we are muted.
So you have not been able to hear us for the last minutes?
No, it was just the sound from the computer.
Not the sound.
Because otherwise we hear ourselves.
That's good. Yes. Just to have this, I think that just to put up the question from Eva Schmidt again, statistically, if you go by yourself to the court, what are the chances compared to?
I have no data. Why? I should conduct this research.
Is it considered impossible?
No. There are many cases in which the convicted person the one who initiates the proceedings, and and the case is successful.
So from the 10 to 15 cases.
No,
the GCR, which are actually, how many of them are brought by the prosecutor, would you think? Would it be half of them, or would it be?
I have no data of this because I haven't checked it. The only data that I can provide to you today is that there are 250 petitions per year, and only between 20 and 30 are successful. From those 20-30, I'm not sure how many of those were brought by the public prosecutor office. It depends on the year, and it depends a lot of the type of crime.
Yep.
Because, for example, vicinity cases are usually brought by the public prosecution office because they have the data. They have two judgments, and it's obvious that they have two judgments, so they bring the case.
Okay. And just to wrap it up, I don't know if people could raise their hand if they have important questions for Professor Miret. Then we're closing very soon. We will not continue the webinar much longer. We just have the opportunity here to delve into the keynote again. There is a hand again from maybe, I don't know if it could be just see. Eva Smith, do you have any other comments? Could you, Eva Smith, do you have any other comments? Doesn't appear to be the case. We just jot it down. I think. So I think I'll just end up, unless people raise their hands, I'll just due to last 5 minutes to a few follow-up questions just to make sure that we got everything right here about the procedure. It was maybe also just for pedagogical reasons that I mentioned that you sort of have a second chance. It was just to say that how should you approach this case? What was
It's strategic.
Yeah, a choice. That what would be a strategic choice would probably be to try to permit the prosecutor to start the case. Regardless of whether you prepare the case for the prosecutor or if you take the case to the Supreme Court, how important is the role of the attorney here? I mean, I'm sure that it would always be good to have an attorney doing a good work on the case, present the case in a good way. But many of the cases which are taken up, I mean, are they presented in your organization, for instance, when you have assisted some of your the University of Barcelona's legal clinic has assisted some people in trying to reopen their cases, or how? Yep.
Well, as we are a legal clinic, we don't assist people. We just write a memorandum that we give them with our opinion. And so if we think that they have options, we recommend them to go to a lawyer and who can consider, obviously, our memorandum. The lawyer, at the end, it's free to decide if in his or her opinion, the action can be successful or not, or if they want to follow our opinion or not. But as we are an academic institution, we can not have the standing, and so we prepare memorandum with all our conclusions, and this memorandum is given to the person that has asked for our opinion, our help, and then it's up to them to contact a lawyer who is the one who is going to take the case to the Supreme Court.
Does the Supreme Court, in its procedure, have a sort of investigatory? Are they bound by principles of investigation so that when the Supreme Court receives the complaint,
they can order investigative measures? They can order, for example, the most basic activity could be to ask the full file to the lower court or the full who issued the judgment, and afterwards they can order to carry out other investigative evidence. For example, in DNA cases, if in DNA cases, you don't usually attach DNA report to your petition. You just justify that a new DNA test could be done, and you explain why, and you have to explain that this is a new evidence, why it is a new evidence, why it was out of your reach when you were convicted, and you have to explain and to justify that you are fulfilling all the requirements, but the DNA test is going to be carried out. It's going to be ordered by the Supreme Court and is going to be carried out by the public services.
And let's say, just to add it here, that we have the Spanish Supreme Court reviewing the case. It would be reviewed by the judges in how whether they received the complaint. It will be the judges of the Supreme Court that would review it. Would it be It would be the second chamber?
Yes.
That you mentioned. How many judges would review the case?
It's 5.
5. And we will have 5 judges from the Supreme Court looking at the case, looking at the complaint from either prosecutor or from Samsam himself. There would be 5 judges looking at the case and deciding whether they would take it or not. So 5 judges will be involved.
Yes.
Yes. And if they, regardless, they don't have to open the case. I mean, if they look at they don't have to sort of investigate. When they open the case, and if they have any questions, they can by themselves ask for the judgment from the district court you mentioned. Yeah.
Yes, exactly.
And they can ask for more information, also information from the Danish state, for instance.
Yes, in your petition, you can suggest or ask the Supreme Court to conduct those investigative activities that you think that can be useful for the investigation, that you need to justify that they are new and why they are relevant, why they are possible, and why you need them.
Yes. And could you imagine that they would cut off the case immediately before they reach that point, or would they always consider it? So, for instance, if we say
they can cut the case before ordering those activities.
Yes.
If they think that these petitions are not relevant at all, that they are not going to make any difference, or even in a more positive interpretation, if they think that they already have information enough to decide, if they get to a conclusion that you have brought a very good piece of evidence in terms of way, they may get to the conclusion that they don't need further activity to get to the conclusion that the evidence was relevant.
But in theory, they could ask the Danish state to confirm, ask follow-up questions to the Danish state if they wanted to.
Yes, they could, because judicial cooperation is possible.
Yes.
I understand that also international judicial cooperation and also any other type of investigative measure that has been set in our legal systems. So,
excellent. And if I may wrap up the seminar now with a few conclusions and what I've learned personally, what's actually is new here today, and I'm really grateful that we could have this explained by Professor Miret. The fact that, first of all, we have sort of, you can say that we had 2 procedures, because first of all, we could go to the prosecutor, or Mr. Samsam, the Danish state, could go to the prosecutor and give them the Supreme Court judgment and say, this is new evidence, then the prosecutor could consider whether that would be a possibility and start the case. If that would not work for Mr. Samsam, then the case could be brought by Samsam's lawyer himself to the Supreme Court. And even in that case, if there are some unclear questions, then Mr. Samsam's attorney could tell the Supreme Court, we don't know this and this, but but we would ask the Supreme Court to ask the questions, and they would consider that, and it could be, in theory at least, a possibility for them. So they could sort of also assist in clearing up some of the cases according to Spanish procedural law. And in my understanding, and I must say that from visiting you, our conversations yesterday also, and also during this seminar, convinces me that this is a very different procedure from what we know from Denmark, the den særlige klagebarns and that would be and therefore it is a case which I've learned something new today based on this. First of all, these 2 points about the prosecutor's role in this, and also just the fact that it is actually something that is regularly happening, that cases are being brought before the Supreme Court for reopening of cases. But Professor Miret, I don't think we have any questions, but I'm also going to close the seminar now. If you have any comments to this in writing or anything, then feel free to get back, and we might be able to follow up on this. But I would like to thank you, and also this is a good opportunity to briefly present you, of course, your legal clinic work, where you actually work with with the name of the
Barcelona Innocence Project.
Yes, and that is also a very interesting initiative to bring on this matter. Professor Miret, thank you so much for your time here. It has been great to visit you here at Barcelona, and also thank you for the participants in this seminar, which I believe has given us a lot of knowledge about the Spanish reopening system. Thank you very much.
You're welcome.